It seems like you want to go to prison.
I do not, ma'am.
Then,
I know to be better, I have to do better. And since I've been in here, I've done every class that they could give me. I'm trying to do better. I
here's
do
the thing,
understand
people
that.
always do better when they're in jail. Normally, I will have people, they come before me, and when they're in the free world, they don't do what needs to be done. When they're in the jail, it finally hits me, oh, I'm in jail. And then they start taking every class they have at the jail. People always become focused when they're in jail because they don't want to go to prison or they don't want to be in jail. So my question for you, why would this be any different than before? You can either do 5 years in the prison or either you are going to do 10 years deferred adjudication. Those are your two choices. All right, the court is calling 2025 CR 008991 State versus Audrey Bash. Could I have parties announced for the record?
Joseph Stateson for defense.
And are you Miss Bash?
I am.
All right, you entered into a plea bargain agreement with the state. You've applied for deferred adjudication and also for community supervision. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. This is the run concurrent with 2024 CR 2272. State will take in consideration 2025 CR 008992. Have both parties had a chance to review the TAP evaluation and PSI?
Yes, sir.
Yes, Your Honor.
Any objections from either party?
No, stay here.
Just a few corrections, Your Honor. I reviewed it with my clients. And you have a copy of it?
Yes.
On page 1, although this goes more towards argument, guilt minimalized, on the PSI specifically is for the firearm. I believe what they're referring to is for the case that's being TIC'd, but she admitted there was a firearm. And for argument, I will explain further for that, but she didn't minimalize the handgun. She acknowledged there was a handgun. On page 2, everything's correct on page 2, but on page 3, under other cases outside Bexar County, Kendall County, Texas, she said that there was no state jail prison trip on Kendall County.
Okay.
It was only one state jail trip on page 2, one TDC trip on page 2, and she didn't have a third trip to prison. Same page 3, Tarrant County. Just so the court's aware, April 9, 2025, under Tarrant County, Texas, she was in custody here. The typo, it should have been 2015. If you look at the convicted 180-day jail, 11/23/2015. I just don't want the court to be thinking that she had a out-of-county case April of this year when she didn't.
Okay.
Also, page 5, where it says unemployed, she did report that she's self-employed. She has her own landscaping company. She's able to provide for herself if she was to be granted probation. On page 6, it says that she, although to the left it says none for DWI education, to the right it says yes, which could be for AANA. She has done AA. She just wants the court to be aware that she's never had a DWI. She's never had to take DWI education class. And page 9, although this is not really a correction, it's just so I can point out, they wanted proof of full-time employment under other within 30 days and provide proof of education within 30 days. She's saying that she received 2 GEDs, one in Arizona, one in Texas. In 2001 and 2017, she did have a GED. The 2017 was in Bexar County Jail. Aside from that, there's no other corrections, Your Honor.
All right. State, you're opposed to the application?
Yes, Judge. Yeah, again, I don't have any evidence.
Okay. All right. Anything your client wishes to say?
Yes, Your Honor. I would like to call her, but if I can do some argument first. We were here previously.
Well,
Okay.
I think it's best that I take testimony and then I'll allow both parties to do argument.
Can I call Audrey Bash?
Yes. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand.
Ms. Bass, you're currently on probation supervised from this court. Yes?
Yes.
All right, you need to speak up so the court reporter can hear.
And you're asking this judge to grant you reinstatement and probation on this new offense?
Absolutely. Yes, yes, yes.
You're willing
Okay,
to
so here's the thing. I can barely hear you. You're a distance away from the court reporter. I know the court reporter is struggling. You need to speak up.
Yes, ma'am.
Yes.
you're willing to do anything this judge imposes of you for probation?
Absolutely.
And
Then, I'm sorry. Then why haven't you been doing it? Like people always say, I'll do whatever you want me to do on probation. You're already on probation. In your statement on page 7, it states, when asked why she felt she should be granted probation, the defendant stated, it's hard to be in jail. I don't want to be here or in prison. If you don't want to be in jail and if you don't want to be in prison, then why do you keep doing this?
I was doing my classes. I was told to do the IOP classes here. I did 18 out of the 20. The day I came to jail would have been my 19th.
But we're here for a new case. That means that you picked up a new offense.
Yes, ma'am.
So why? Why do you keep doing this? It seems like you want to go to prison.
I do not, ma'am.
Then
I know to be better, I have to do better. And since I've been in here, I've done every class that they could give me. I'm trying to do better. I
here's
do
the thing,
understand
people
that.
always do better when they're in jail. Normally, I will have people, they come before me, and when they're in the free world, they don't do what needs to be done. When they're in the jail, it finally hits me, oh, I'm in jail. And then they start taking every class they have at the jail, as evidenced by the fact that your counselor is saying, I've done my GED twice, when you only need to do it once. But people always become focused when they're in jail because they don't want to go to prison or they don't want to be in jail. So my question for you, why would this be any different than before?
Your Honor, I'm old, and I know that I just don't want to do this anymore. What happened was I let fear control me and make a bad decision, and that was wrong. I was being threatened.
So how old are you?
42.
So you've had this MTR since last year.
No, ma'am.
Well, you were placed on probation on 2024.
September, and
So I mean, you were maybe a year younger than you are today.
and I was really trying to do everything that I could, and I do believe that I can do better. If given the chance, I know that I can do better. I can be better. I can do better. I do
Your Honor,
believe that.
the threatening that she had, she is a victim of robbery. I tried to find it. I went back in time on YouTube to try to find it. There's a case here, family violence. Rick is familiar with. I've asked Rick to pull up the case information. He couldn't find it. I was in court here, and there was a Spanish sentencing, and there was a person who was very loud, talking in Spanish. I don't speak Spanish, but when the state had said that there's multiple victims, that lady was sentenced to prison. They said that the restitution was owed to Audrey Bash, but they didn't know her location at the time. I've asked them to try to find that. I couldn't find that case. I don't have a way to search that. But she understands that a gun is not supposed to have a gun on felon's probation. If she were to have a gun after the 5-year period elapsed after he was discharged, cases ended at her house for protection. But she had some bad relationships. She had struggled. She had a relapse. She wants to be a licensed clinician, dependent counseling to help other addicts recover. She believes she can stay sober. She won't be around firearms. I've never had somebody take upwards of 20 classes at the jail. People usually take 2 to 3. And she, not only took, I think it was 19 classes, but the AA meetings and 10A meetings she's done, it's multiple. It's not just 1 or 2. She's actually participating. She's not crossing her arms, defiant. She's willing to do probation. It's her first MTR. I know that there's 2 new offenses, hoping that you can give her a chance.
All right, state.
I guess I did have some questions for the defendant.
Oh, you may proceed.
Ms. Bash, so you were placed on felony probation in September of 2024, correct?
Yes.
Okay, and so as part of your conditions of probation, you were supposed to report to your probation officer. Do you recall that?
Yes.
Okay, and so it would appear that the last time that you reported to your probation officer was in February of 2025. Is that correct?
No, I didn't. March also, I was in my class and my teacher, we reported by phone.
I'm talking about going to the probation officer and meeting with your assigned person at the field office. Okay, so the last time you did that was in February 2025, correct?
Yes, ma'am.
Okay, and the address that you provided to probation at the time that you were placed on there was 1126 King Avenue, apartment 6. Were you living at that address up until your arrest?
No, yes, no, ma'am, I had moved, but I told them on my mother.
Okay, and what was you told them your new address?
Yes.
Okay. Now, as part of, because you are on felony probation for drug possession, you acknowledge that, right?
Yes.
Okay, and so part of the conditions that the court placed on you to help address this issue is for you to go to partake in urinalysis. You recall that,
Yes.
right? Okay, and so you had been ordered many times. So starting in January 2025, you did report to provide a urinalysis. Is that correct?
Yes.
And that was positive for amphetamines and marijuana, correct?
I believe so.
Okay, and then in February of 2025, you did not appear to provide a urinalysis, correct?
I don't remember. I don't remember being told to do it that day.
You don't remember being told to do
No.
it that day? Well, I guess it's fair to say the last time that you did it was in January of 2025, right?
Okay.
So the last time that you provided urinalysis was in January of 2025?
Yes, ma'am.
Okay, and so then in your PSI, you deny that you were under the influence of any alcohol or drugs at the time of your new arrest. Do you recall that?
Yes, ma'am.
But when we look at the stipulated evidence, the officer states that when he approached you, you appeared to be sleeping in your vehicle. Do you acknowledge that?
Yes, ma'am.
Okay.
It was raining and the roads were wet and I pulled over rather than getting in an accident, I fell asleep driving one time before and I killed myself. And I would rather not do that again. I wasn't on drugs because if I had been, I would have been awake.
Okay. And so
I
what
didn't
is
know
this
they
that the
were-
officer is saying that he could smell marijuana in your motor vehicle?
I was asleep. I wasn't smoking, I was asleep.
So when was the last time that you smoked marijuana in that vehicle?
I don't remember.
You don't remember? Okay.
And I don't think it was me. I think it was the person that I let my car to. Earlier that day.
Okay. So then further in your PSI, you state that the last time that you had used methamphetamines was 10 months prior to your arrest. Is that what you said?
I believe so.
Okay, but
I
you were found in possession of methamphetamine
I
on the
did,
date
yeah.
of the offense, correct?
I did not know that it was there. If it had been mine, it would have been on my person. I would have known that. I didn't know that it was in the floorboard of my car because I gave somebody a ride to work. It would have been, in my possession. I really did not do that.
Okay, well, notwithstanding you disputing those facts, okay? You were arrested in May of 2025 and had a positive UA while on felony probation for methamphetamines in January 2025. So please tell me how many months that is. It's 5, right? Not 10. So you're not being truthful to your PSI officer or this court about what you're doing on felony probation, correct?
Yes, ma'am.
Okay. And then further in your PSI, you're stating that you should be granted probation because you don't want to go to jail, not because you want to change or not because you want help, correct?
I want help, ma'am. I would like help. I'm trying to be a better person. I'm doing everything that I can to be a better person.
Okay, so if you wanted help, why did you not reach out to your probation officer? Or why did you not show up to your UAs? Or why did you not show up here to the court to ask for that?
I was doing the classes and I was doing the classes that they gave me, the IOP classes here at the probation office. I had reached out to my teacher and told her that I was having a hard time. But I was doing that. I mean, I thought that there would be a record of that.
Did you notify anybody that you were actively engaging in using controlled substances besides your IOP teacher?
No, ma'am.
Okay, because you understand that the IOP teacher is not the correct person to report that to. It's your probation officer, right?
Okay.
You understand that?
I'm doing that. Yes, ma'am.
And so I guess ultimately what you're telling this court is that you just don't want to go to jail or prison because it's hard, right?
No, ma'am.
That's what you
That-
stated in your PSI, right?
And it's not that that's not it at all. I would really like to be given a shot to be a better person, to do better, to prove to myself in the court that I can do better. Prison is easy. I mean, you do what they tell you to do and that's it. But when I've done probation, I've free and cleared probation with no violations. I've free and cleared parole with no violations. I believe that I can do better. I truly do. I want to be better. I know to be better, I have to do better. And I'm prepared to do that. I know that probation is very rigorous and I'm prepared for those things. Anything that you give me, and I'll be happy to do. I want to be better and do better and help others be better and do better.
Okay.
I believe that.
Well, would you agree with me that given your history, the state and this court has already given you a chance by placing you on felony probation? And here we are because you cannot violate or you cannot abide by the terms of felony probation. You'd agree with me, right?
I believe that I made a mistake once and I would really just beg mercy to please get a second chance.
When you say that you've made a mistake once, I mean, this is not the first time that you've been charged with a criminal offense, correct?
Mm.
Yeah. So that's more than once, right?
I'm asking for a shot, a second shot for this, but I don't know what to say to her anywhere. She's
May I briefly respond?
bad.
All right, so I'm going to give you a choice today. These are your choices. There are no other choices. One, I can place, you say you want the help, I'll give you deferred adjudication. The state is offering you a cap of 6. If I give you deferred adjudication, the full range of punishment is open to the court, which means up to 10 years in the prison. You are not going to ISF. I don't think ISF is appropriate. You'll be at the jail waiting transfer to SafeP. And the SafeP program is a 9-month program. And then you have aftercare for 3 months. Or if you would like, I'll sentence you to prison. I'll sentence you to prison for 5 years. Those are your only 2 choices. Which do you choose? And see, this tells me right now, she really doesn't want the help, that she's trying to figure out back time. But you can discuss it with her. No, those are my only 2 choices. Those are your only 2 choices. There are no other choices. You can either do 5 years in the prison, or either you are going to do 10 years deferred adjudication. Those are your 2 choices. No other choices for you. So which do you prefer?
I'm sorry.
1 moment.
All right.
Oh.
And if she chooses prison, it doesn't hurt my feelings.
Your Honor,
Yes.
we're ready to proceed forward. She has her answer.
Right. So which does she prefer?
5 years TDC, and we would ask that would run concurrent with her MTR. We would ask if you would reform the judgment of the 10 to 5.
Oh, just 1 second. We haven't done that case yet. All right. So in cause number 2025 CR 008991, the court will sentence you to 5 years in the prison. I'm sorry, the court is going to find you guilty, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 227. I'm sorry, is this 2272 or what? 2272. Take in consideration 2025 CR 008992. And I'll request the therapeutic community. Is there anything else in that case with regards to sentencing?
Yes.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
I do.
All right, we're going to proceed in 2024 CR 2272, and that cause number you previously pled true to violation of condition number 1. The court found violation of condition number 1 true. And your range of punishment on that case, the court could sentence you anywhere up to 10 years in the prison. And state, what are you requesting?
Judge, we are asking for revocation and 5 years to run concurrent with the prior cause.
That's our recommendation. We ask that you follow it. I've previously conferred with Megan. If there was revocation, we would ask you to reform the judgment to match the sentence.
All right. Are you waiving your right to appeal?
I am.
Okay.
Thank you, Judge.
All right. And that cause number, the court is going to sentence you to 5 years. Give you credit for any time served. This will run concurrent with 2025 CR 008991. And the court will request the therapeutic community. State, you may be excused. Thank you. Did you review the document certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. Do you understand?
I do.
All right, good luck to you, Manuel Ramirez-san. Thank you. And are there applications?
No, Your Honor.
All right, probation, there are no applications. Court is calling 2025 CR 013930, State versus Manuel Moses Ramirez. Could I have parties announced for the record?
Lauren Espinoza for the state.
Sean Sheffield for defendant. We're ready, Your Honor.
All right. And are you Mr. Ramirez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. All right, I'm trying to find your true bill of indictment. All right. Yeah, it's not here. All right, thank you. Oh, no, found it. It was stuck to another document. All right, Mr. Ramirez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, ma'am.
Your client needs to sign that.
Oh, I'm sorry.
Today in court, the judge reviewed a probation violation case. The judge asked clear questions. Why were reports missed? Why did a new offense happen? The court said words are not enough. Actions matter. The defendant was given two choices: strict treatment on probation or prison time. After thinking, the defendant chose prison, with time served counted. This case shows the court gives chances, but responsibility is required. Like, share, and subscribe for more real court case breakdowns.
No problem. All right, your charge of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ramirez, has anyone threatened you,
No,
coerced you, or placed you in fear to get you to enter this plea?
no, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand
I
it?
do, ma'am.
According to the plea, punishment is to be assessed at 12 months in the state jail facility. There's $1,000 fine and no applications. Did you understand that to be the plea?
No.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both
I
places?
do.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? Guilty,
Guilty.
not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, state offer States Exhibit 1 and all attached with.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Sure do, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
we would ask you, so, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just asked the court to follow the recommendation.
All right, the court will sentence you to 12 months in the state jail facility, give you credit for any time served. There's $1,000 fine, time and money to run concurrently, and I'll suggest the therapeutic community for you.
Thank you, Judge.
The therapeutic community doesn't increase the time that you're in custody. It's just to help you with your sobriety. I do not have the authority to force them to place you in the program or order them to place you in the program. They'll just see on the judgment that I'm recommending that for you. When you get to the state jail facility, you'll have to request it as well. Do you understand?
Yes, ma'am.
All right.
Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess. You're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do.
All right, we can go off the record. Here's the thing. How old are you?
I'm 41.
All right, you're 41. If you continue on the path that you're on, only one or two things are going to happen. Either you're going to end up being in prison or the Bexar County Jail or somebody's jail for the rest of your life, or either you're going to end up using, and the last time you use may be the last time you use, because you never know if you're going to overdose, if somebody didn't make it correctly or what. You understand? because the people who are selling that, they're usually not concerned about the person, because otherwise maybe they wouldn't be doing it. It's usually selfish reasons, all right? When you're released from custody, if you can't find a place that can help you with your sobriety, you come back here, I'll pick up the phone and I'll see if I can find transitional housing for you.
I appreciate it.
And in that police report, I saw that you were with someone. You can't help somebody until you help yourself.
Right.
So if they're using, it's not good for you to be around them because they're going to feed into your use. All right.
Yes.
All right. Good luck to you. Thank you,
Thank you.
counsel. All right. Can I see the 765 State versus Angel Joel Varela? Could I have parties announced for the record?
Ashley Jones for the state. Here at court before, Mr. Varela, Your Honor.
And are you Mr. Varela?
Yes, Your Honor.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it?
Yes, Your Honor.
Are you the same Angel Joel Varela who's placed on deferred adjudication in 2019 CR 7765 for the offense of burglary of a habitation with intent to commit assault on June 13, 2022 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We are going to go forward on violation of condition number 1 from the supplement on first amended motion to revoke. That is on or about the 17th day of March, 2024 in Yuma County,
Oh,
Arizona.
I'm so sorry. I don't have the supplemental.
Uh-huh.
All right, did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney as well?
That's the one I signed, correct?
No. It's telling you,
Oh, yes, yes, Your Honor.
all right, the supplemental motion is telling you what allegations the state is saying that you committed that are a violation of your probation. Do you understand?
Yes, Your Honor.
And did you review the supplemental with your attorney as well?
Yes, Your
All right, they're just going to get that for me because I don't have it. All right, thank you. Sometimes it gets lost in the system. Thank you. All right, state, you may proceed. Oh, it's still the First Amendment. I thought you said supplemental.
No. I corrected first amended, Your Honor.
Ah, then I have that. All right, let's proceed.
All right. On or about the 17th day of March, 2024 in Yuma County, Arizona, the defendant Angel Joel Varela committed the offense of aggravated driving under the influence in violation of condition number 1.
How do you plead to that? True or not true?
Honor.
And the state will waive the remaining violations, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that the court grant the the state's motion to enter adjudication of guilt, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
All right. Is that what you're requesting, counsel?
It is, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. And can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Angel Joel Varela.
All right. What have you completed on probation?
Well, Your Honor, on probation, I was going to work, being a law-abiding citizen, just trying to do my best to stay out of the way. I'll be a good father to my kids. And really, just my cousin, he passed away. I was really close to him.
Just stop in real quick.
Yes.
While I'm thinking of this, when we signed the paperwork, I told him he did have a limited right to an appeal, and you did ask him if he was waiving his right to appeal. So can I just explain to him what that means?
Sure.
Yes. Okay.
All right. So what have you completed?
Having a job and being there for my kids.
I mean, everybody does that.
And while I was in prison, I completed anger management classes. I completed a cognitive behavior classes.
So you've been sentenced on the other cases?
Judge, he was sentenced to up to 2.5 years in Yuma, Arizona. I believe he did a year and a half. If I'm reading the
Do
judgment,
you know that cause number?
yes. You ready?
Yes.
It's number S1400CR 2024000523.
All right. So you completed cognitive and that was while you were in custody?
It was just anger management
Cognitive anger management, there's another one.
and behavior analysis.
And that was while you were in custody?
Yes.
And that happened while he's on probation.
Okay. All right. This is what the court will do. The court is finding violation of condition number 1 true, and that's the violation with regards to aggravated driving. The court will grant the state's motion, revoke, sentence you to 3 years in the prison. This will run concurrently with S1400. Did you say CR?
Yes, Your Honor.
CR 2024000523. There's an affirmative finding of family violence. There's to be no contact with Liliana Martinez. There's to be no unsupervised contact with minors. There is a $1,500 fine. Time and money will run concurrently. And according to your plea bargain agreement, there's no outstanding restitution. Is there anything else with regards to sentencing?
Not in the state.
Judge, it's just he wants me to make sure he's getting his back time for all the time he did Bear County, which I know I think he's entitled to, right?
Yes.
And then you're giving him his credit for the time that he served on this case in Yuma?
Yes, and it's running concurrently. And legally, I must give you credit for any time served.
Okay.
So that's, sometimes I don't say it because it's automatic and your attorney knows that it's automatic. But sometimes we forget that people who are not in the legal field don't know. So the record is clear. You're entitled to credit for any time served that you're in custody on this case. And you're entitled for any credit for any time that you were in custody out of state, as long as this warrant was pending. So if there was not a warrant pending and you were doing time somewhere else, then you're not entitled to that credit. Once a motion to revoke was filed on this case, then you're entitled to credit from that point. And your attorney will check to make sure that that is accurate. All right. And if for some reason you go to prison and you find that it's not accurate, what will usually happen is we will receive a letter, it will be reviewed. And usually if everything is correct, what you're saying, someone will double check it. And then when they double check it, I'll sign a motion or an order granting you any time that you feel that's appropriate. You understand?
Yes, Your Honor.
And that's proven to be appropriate. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to
In
own or
this court
possess any
case,
weapons
the
or
judge
ammunition.
reviewed a
If you have a
probation
question over
revocation
that, you'll
for
need to speak
Angel
to an attorney.
Joel
Do you
Varela.
understand?
Yes.
He admitted to
All right, if you
violating
go off the record,
probation
do
by
better.
committing
Otherwise, you're gonna
aggravated
find
DUI
yourself
while
living
on
your life
deferred
in somebody's
adjudication.
prison or
The
somebody's
judge
jail. You
clearly
understand?
asked,
Yes, Your Honor.
All right,
"Do
good
you
luck.
understand
Sometimes
this
I don't
can
say
send
it
you to
because it's
prison?"
automatic. And
After pleading
your
true, the
attorney
court
knows that
revoked
it's automatic.
probation and sentenced
But
him to 3
sometimes we
years in
forget
prison,
that people who are not
running
in the legal
concurrently
field
with another
don't know.
case.
So
The
the
judge
record is
explained
clear.
credit
You're
for
entitled
time
to credit
served,
for any
no
time served
contact
that you
with
were
the
in custody
victim,
on this
and
case.
limits
And you're
involving
entitled for
minors.
any credit
The
for
message
any
was
time
clear.
that you were in
Probation
custody
is
out
a
of state,
chance, not a
as
free
long as this
pass.
warrant was pending.
Like, share,
So
and
if there was
subscribe
not
for
a
more
warrant
short
pending
court
and
case
you were doing time
breakdowns.
somewhere else, then you're not entitled to that credit. Once a motion to revoke was filed on this case, then you're entitled to credit from that point. And your attorney will check to make sure that that is accurate. All All right, and if for some reason,
2024 in Bexar County, Texas, the defendant, Michael Joseph Mora, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
how do you plead to that, true or not true?
State will waive the remaining.
Any objections to the state's waivers? Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, and sentence you to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 2 and 2?
Yes, Your Honor.
Court will find violation of conditions 2 and 2 true. Is there a proposed agreement?
There is, Judge, the proposed agreement is to deny state's motion, alter and amend conditions to add mental health evaluation as well as follow those recommendations.
All right, and what is that based upon?
Based on the court summary here, there is notation from the probation officer that he may be struggling with that mental health, as well as I believe defense would probably be able to speak to that better than the state.
Judge, we're in agreement with the state's recommendation. Mr. Moore suffers from mental health diagnosis, and we believe that he would be better served being supervised by the MIC unit and receiving treatment through probation.
If he's drug tested, if you're you want to raise your right hand for me, please? Do you solemnly swear affirm the testimony you yield will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Michael Mora.
Right. When you're drug tested today, what are the results going to be? And you are going to get drug tested today. I'm sorry.
Negative.
All right. What we're going to do is we're going to have you drug tested today, and I will make my ruling when you come back. Okay.
Thank you.
Just 1 second. Still on the record, the court is finding violations of 2 and 2 true. Probation,